Section 12 of the Terrorism Act 2000 aims to stop individuals supporting proscribed organisations. And supporting here means anything from speaking at a meeting to invite people to support a proscribed organisation to arranging those meetings. In recent years, individuals have been found guilty of supporting proscribed organisations such as National Action and Daesh. Section 12 creates 4 terrorist offences which all relate to supporting a proscribed organisation in some way. One of these 4 terrorism offences, Section 12(1)(a), has been severely criticised as a thought crime, a new offence introduced in the Counter-Terrorism and Border Security Act 2019. And please note, a proscribed organisation is one which is banned in the UK, and there's currently over 80 groups proscribed. Recent additions to the list of proscribed organisations include National Action, proscribed in 2016, and Hezbollah, proscribed in 2019. Please watch the full video on proscribed organisations who's on the list. The 4 terrorism offences under Section 12 are as follows. Offence 1. Section 12(1). A person commits an offence if he invites support for a proscribed organisation. Now the key to committing this offence is the prosecution needs to prove the person knowingly and deliberately invited support for a proscribed organisation. And here's a selection of proscribed organisations with their very brief political aims highlighted in red. ETA, Hamas, Baba Khalsa, IRA, ISIS, November Revolution 17, PKK, Loyalist Volunteer Force, and the Liberation Tigers of Tamil Eelam. It would be a defence for a person to argue that their comment was not in support of the proscribed organisation, but a comment to support a political aim which they happen to share or be similar with the proscribed organisation. Offence 2. Section 12(2). A person commits an offence if he arranges, manages or assists in arranging or managing a meeting which he knows is to support a proscribed organisation, to further the activities of a proscribed organisation, or to be addressed by a person who belongs or professes to belong to a proscribed organisation. For example, a person would commit this offence if they organise a closed or public meeting. There is a defence for a person who arranges a private meeting to prove that he had no reasonable cause to believe that the address by the speaker would support a proscribed organisation or further its activities. Offence 3. A person commits an offence if he addresses a meeting and the purpose of his address is to encourage support for a proscribed organisation or further its activities. This offence captures a person who is the invited speaker to these meetings. Offence 4. Section 12(1)(a) says this: a person commits an offence if the person expresses an opinion or belief that he is supportive of a proscribed organisation and in doing so is reckless as to whether a person to whom the expression is directed will be encouraged to support a proscribed organisation. As with Section 12(1) above, Section 12(1)(a) offence, there's no minimum number of people to whom the expression is directed at. This means an offence can be committed in a one-to-one conversation, and the offence can be committed in both private and a public place. Now, this new offence has been subject to much debate and criticism, and 8 have been mentioned here. What's the reason why this new offence was created is stated in the following way. We believe that this type of radicalisation should be illegal in order to stop the support for these groups and to protect the public. 2. With this new Section 12(1)(a) expressions of support offence, it's no longer necessary to prove a person must knowingly invite support for a proscribed organisation, but simply be reckless as to whether they will encourage support for a proscribed organisation. In effect, this means that a person who shares the same or similar political ambitions, opinions or beliefs as a proscribed organisation can commit this offence through reckless comments. 3. An example is given by Professor Clive Walker where he says, thus, I might say that I support the political objectives of the IRA in the sense that I agree with their aspirations for United Ireland. Of course, I might qualify that statement with a rejection of their violent means which they say they renounced some time ago. But that qualification does not afford a defence since I am still supporting an organisation which is proscribed. 4. Another example is this: a person may commit a Section 12(1)(a) expressions of support offence if they express a general desire for a united Middle East where the Sharia Islamic rules supreme, as this places them at risk of supporting the similar political ambitions of a proscribed organisation, in this case AQ. 5. There is no defence for a person who expresses in a non-violent way the same political objectives as a violent proscribed organisation. 6. This new offence will certainly make it easier to prosecute individuals who share opinions and beliefs with proscribed organisations. This gives a great deal of police and prosecution discretion as to who they investigate and prosecute, and thus the argument goes is liable to be abused. 7. Liberty asserts that by removing the requirement of the intention to invite specific support for proscribed organisation, in doing so it pushes the law even further away from actual terrorism into the realm of pure speech and opinion. Now this new offence accordingly may restrict political expression, create a level of uncertainty about what can be said within the law, and thus this offence is likely to have a potential chilling effect on protesters, speakers, political groups, particularly those campaigning for political changes abroad. And 8. Some suggest that without an actual encouragement to acts of terrorism, this offence is akin to a thought crime, an observation again made by Professor Clive Walker when he says, in the absence of that emphasis on an outward facing action, the offence might be criticised as a thought crime. The maximum sentence for committing any one of these 4 terrorist offences under Section 12 is 15 years in prison. Thank you for watching. Please watch more videos in the terrorism law series. Please subscribe. Check out our website www.cleadvideos.co.uk. Please speak to a solicitor if you need specialist legal advice, and may the justice be with you.